We often think of the Supreme Court dealing with these huge, really big headline issues.
Yeah, the landmark decisions.
Exactly. But sometimes it's in the cases that seem almost small, almost every day, that you see potentially massive shifts happening. Take AJT versus Osseo. It's out of Minnesota. It's about a student, Ava Tharp. She has epilepsy. And her family, they just asked the school for a slightly later start time.
Seems pretty reasonable on the face of it.
Right, just to help manage her condition. But the school district, they said no.
Okay.
And now this very specific, very personal situation, it's actually landed in front of the Supreme Court. And it might just reshape the rights of students with disabilities everywhere.
It's amazing, isn't it, how these really pivotal moments can come from something so well localized.
Yeah.
And to really get a handle on what's going on here, what's at stake, we're diving into an analysis by Dr. Jaime Hoerricks.
Yes. The autistic forensic scientist turned educator.
That's the one. Dr. Hoerricks has this really fascinating way of seeing connections, like a talent for spotting the underlying machinery in different systems.
Totally. And what's so striking about their take is how they link this education case, A.J.T, to two really significant legal precedents from forensic science. Stuff that seems, well, completely separate.
Right. Youngblood versus Arizona and Daubert versus Merrill Dow.
Exactly. It feels like they're uncovering some kind of hidden thread, a logic connecting these really different legal areas.
Precisely. So our mission, if you will, for this deep dive is to follow those threads Dr. Hoerricks has pointed out.
Okay.
We want to understand why this seemingly straightforward request about a school start time could actually ripple out and affect the rights of disabled students so broadly. We're trying to look past the surface details,
And unpack the deeper sort of systemic stuff that's going on.
Yeah, exactly.
Okay, so let's dig in. Dr. Hoerricks talks about their autistic spidey sense. This way they process information associatively, making these pattern connections that maybe others miss. And this is what sparked the link between A.J.T, Youngblood, and Daubert. So what's the central idea tying them together?
Well, the really compelling phrase Dr. Hoerricks uses is the institutional exoneration of harm under the guise of professional discretion.
Okay, say more about that.
The argument is basically this. Across different fields, how police handle evidence, how courts weigh expert testimony, how schools meet student needs, there's this tendency. Institutions can often avoid accountability for harm they cause.
If they can say they were just following procedures.
Exactly. If they claim they were acting according to professional standards, with good intentions, exercising their professional judgment, the actual impact, the harm felt by the person, that seems to become secondary.
That's quite a framework. Let's start with the first case, Youngblood v. Arizona. That was 1988. What was the deal there?
So in Youngblood, the Supreme Court basically said that the police don't have a constitutional duty to preserve evidence that might help a defendant.
Unless
the defendant can prove the police acted in bad faith, that they intentionally got rid of or failed to preserve potentially helpful evidence.
Wow. And the details of that case were pretty grim, weren't they?
Yeah, really disturbing. A child sexual assault, a man wrongly convicted, and critical biological samples, semen samples, that were improperly refrigerated and degraded. They could have potentially exonerated him, but they were lost due to, negligence, essentially.
So the key takeaway is just messing up, being negligent, isn't enough to violate the defendant's rights in that context. The harm only counts legally if you can show malice, bad intent from the institution, the police here.
That's pretty much it. And Dr. Hoerricks points out this real conflict from their forensic science background.
Right, because as a scientist...
As a forensic scientist, the professional ethic, the absolute mandate, is preserve everything. Document everything. Because you never know what tiny detail might crack a case later. But then you have Youngblood, which legally says, losing stuff might be okay if you didn't mean to lose it maliciously.
It sets up this tension. Dr. Hoerricks seems to be suggesting a kind of ethics of consequence deferred, where the person with less power ends up bearing the brunt of that institutional slip-up.
That's a really good way to put it. The harm to the individual is real. It doesn't just vanish because the institution claims it wasn't intentional.
But the legal loophole is there.
The legal framework created by Youngblood allows the institution a path to potentially avoid responsibility for that harm.
Okay, so that's Youngblood. Negligence isn't enough, you need bad faith. Now, let's jump to Daubert v. Merrill Dow. 1993. This one's about expert testimony in court, right?
Yes. Daubert basically tasks federal judges with being gatekeepers for scientific evidence.
Gatekeepers, meaning?
Meaning they have to decide if expert testimony is actually reliable enough to be admitted. They need to look at things like, can the theory be tested? What's the known error rate? Has it been peer-reviewed? Is it generally accepted in the scientific community?
The idea was to keep junk science out of the courtroom, presumably.
That was the stated goal, yes. But Dr. Hoerricks argues that the way it often plays out in practice can lead to what they call epistemic conservatism.
Epistemic conservatism. Okay, what does that mean in plain terms? How does it actually work?
Well, the potential issue is that Daubert, while aiming for scientific validity, can end up sort of favoring the established players, the big institutions, the conventional methods.
Ah, I see.
Dr. Hoerricks talks about being in court and seeing testimony from, say, a state crime lab, get a relatively easy pass. But if someone came in with a newer method, or was from a smaller outfit, or represented community knowledge,
they'd face much tougher questions.
Exactly. Much more skepticism. Even if their science was arguably sound, it became less about whose evidence was better and more about whose credentials the system already recognized, whose knowledge counts.
So it can inadvertently reinforce the existing hierarchies in science and expertise. Dr. Hoerricks uses a really stark example from a case, United States v. Wells, involving some really bad video evidence.
Oh yeah, that one's wild. It really illustrates the point. The prosecution had this tiny, blurry snippet of video showing a vehicle, like 33 by 11 pixels, from 1,000 feet away. Basically a smudge. And they apparently spent millions trying to get experts to say definitively that this smudge was a specific make and model, a Honda CR-V.
Millions on a 33-pixel smudge.
Right. Dr. Hoerricks' point is that the focus shifted entirely away from what that blurry image could realistically show. It became about the process, the expensive analysis, the credentials of the experts willing to make the identification.
It wasn't about the evidence itself, but...
As Dr. Hoerricks puts it, this isn't about what the evidence shows, it's about who gets to say what it means. The procedure trumped the reality.
Wow, okay. So Daubert can become less about truth and more about following the rules and deferring to the usual authorities. And Dr. Hoerricks sees this dynamic echoing in the A.J.T. v. Osseo case, the one about Ava Tharp.
Yes, let's bring it back there. So Ava Tharp has epilepsy. Doctors say she needs a later school start time. It's a medical recommendation for her well-being.
Seems like a reasonable accommodation request under disability law.
You'd think so. But the school district refused. And her family says her health got worse. More seizures. So they sued, claiming discrimination under the ADA, the Americans with Disabilities Act, and Section 504.
And what happened in the lower courts?
They threw the case out. Dismissed.
Why? Did they say no harm occurred?
No, that's the crucial part. The dismissal wasn't because they decided Ava wasn't harmed. It was because the family couldn't prove the school district acted with, and here's the key phrase again, bad faith or gross misjudgment.
Ah, there it is. Echoes of Youngblood. It's not enough that the decision caused harm. You have to show the intent was malicious or the judgment was completely unreasonable.
Exactly. So the question now before the Supreme Court is fundamental. To violate a disabled student's rights, does the school need to have intended harm or shown really egregious judgment? Or is it enough to show the school knew harm was likely, knew about the student's needs, and simply failed to act appropriately?
That is a huge question.
It really is. Because the answer will define whether the law protects disabled students mainly from deliberate malice or also from harmful negligence. And think about the power dynamics.
You're right. A single family trying to prove bad faith against a school district with lawyers and resources, that's a steep hill to climb.
It's incredibly difficult. Which brings us back to Dr. Hoerricks' central parallel. The legal system, in practice, seems to weigh the institution's intent and its claims of professionalism more heavily than the actual lived consequences for the individual, just like we saw in Youngblood and arguably in the application of Daubert.
And based on spotting these patterns, these parallels, Dr. Hoerricks has a prediction about how the Supreme Court might rule in AJT.
They do. Their spidey sense, informed by these patterns, suggests the court is likely to side with the school district Osseo.
Not just a guess, but based on recognizing these legal tendencies.
Right. It's pattern recognition.
So what's the specific reasoning? Why expect that outcome from this particular court?
Well, Dr. Hoerricks points to a few things. First, the current court's leaning towards originalism and institutionalism. There's a general trend of deferring to state actors, to institutions.
Trusting their judgment.
Pretty much. A reluctance to second-guess the professional judgment of people within schools, hospitals, police forces, unless something really egregious is proven. And related to that, there's been a clear trend making it harder for individuals to sue institutions successfully. You often need that high bar of proving malice or bad faith.
The underlying idea being what? That institutions generally try to do the right thing, so harm is usually accidental unless proven otherwise.
That seems to be the implicit assumption baked into some of these legal trends, yeah. Trust the professionals, trust the process, unless there's smoke and gun evidence of ill intent.
And then there's the floodgates argument, isn't there? If they lower the bar for proving discrimination against disabled students.
Right, the fear is always, oh no, schools will be swamped with lawsuits. That's the pushback.
How does Dr. Hoerricks respond to that?
Their counter is pretty direct. They basically say, well, maybe those floodgates opening is exactly what's needed. Maybe that flood is actually the justice that advocates have been fighting for, a real way to get redress when students are harmed by negligence or inaction.
A different framing entirely.
Completely. And they also situate this within a broader context, like the weakening of federal oversight, particularly at the Department of Education in recent years. Fewer guardrails might mean more potential harms going unaddressed until they land in court.
Okay, so this specific case, A.J.T, isn't just about Ava Tharp or even just disability rights in schools. Dr. Hoerricks sees it as part of a much bigger picture, right? This slow-motion dismantling of public institutions under neoliberalism.
Yes, that's the broader frame. They argue A.J.T isn't an isolated incident, but a symptom of this larger trend we've seen over decades at chipping away at public services. Education, healthcare, social safety nets.
How does that dismantling work, according to this analysis?
It often involves things like cutting funds, starving oversight bodies, and bringing in market-based ideas. So in education, you hear a lot of talk about school choice and accountability.
Which sound good on the surface.
Sure. But Dr. Hoerricks argues this language can sometimes mask what's really an extraction process. You see more private contractors, more ed tech companies coming in, often with less accountability. And the focus can shift.
How so?
Well, it can become more about procedural compliance. Does the student have an IEP, an individualized education program? Check. So we do the assessment? Check. The focus on ticking boxes can sometimes become a shield.
A shield against acknowledging actual harm.
Potentially, yes. Like the example given, a child having seizures in class. Instead of that being seen as clear evidence the system isn't working for that child, it might just get logged as a data point in their file. The procedure was followed, the incident recorded, but the underlying failure isn't addressed systemically.
The process itself protects the institution from confronting the negative outcome.
That's the argument. And Dr. Hoerricks connects this to a kind of neo-colonial logic where the discretion held by those in power, the gatekeeping function, ends up disproportionately harming marginalized students, those who don't fit the standard mold.
And this leads to the idea of the enshittification of schooling. That's a strong term.
It is, but it captures this idea that the system's priorities can subtly shift away from the actual needs and flourishing of children towards, say, the interests of vendors, the demands of standardized testing, the metrics that look good on paper.
So if the Supreme Court rules in favor of Osseo, upholding that higher bar of proving bad faith,
Dr. Hoerricks would argue it's not necessarily a radical break from the past, but more like a confirmation, a codification of how the system has already been trending. A system, in their view, not fundamentally built for genuine equity.
It's a pretty bleak assessment of the current state and potential future. But Dr. Hoerricks doesn't stop there, right? They also offer a vision, an alternative, this idea of a truly free public school.
Yes, absolutely. It's not just critique. There's this imaginative element, too. They sketch out a vision that's radically different from the market-driven, often assimilationist model we have now.
What does that look like?
It's envisioned as a collective project, focused on creating relational belonging. Think about the physical space, sensory dignity. So no harsh fluorescent lights, managing noise levels, creating calming spaces.
That sounds very different.
It is, and regulation wouldn't be about top-down discipline, but co-regulation. Understanding neuroscience, understanding nervous systems, responding to needs collaboratively. Things like noise-canceling headphones or fidget tools wouldn't be special ed things, but universal supports available to anyone.
And the learning itself.
Curiosity-driven, less rigid subject boundaries, more storytelling, more hands-on making. And accountability wouldn't be measured just by test scores, but by community care, by how well everyone is supported.
It's a fundamental rethink. And they found an unexpected example, even mentioning old Soviet housing blocks.
Yeah, it's a brief but interesting point, acknowledging all the massive problems with the Soviet system, of course, but noting how the design often prioritized putting schools right in the center of housing complexes, easily accessible, reflecting a collective commitment, at least in theory.
It makes you wonder, doesn't it?
It really does.
Yeah.
What could we actually build if collective well-being was the genuine goal? If our institutions were designed to gather people and support sense-making, not just surveillance and sorting? Dr. Hoerricks frames this kind of imagining not as pie-in-the-sky dreaming, but as essential.
Essential for what?
For survival, for resistance, for actually building something better.
Okay, so let's try to wrap this up. The A.J.T v. Osseo case, viewed through this lens provided by Dr. Hoerricks, connecting it back to Youngblood and Daubert. It really throws this recurring pattern into sharp relief, this pattern where institutional intent, or the claim of professional judgment, often seems to outweigh the actual tangible harm experienced by people, especially vulnerable people.
And Dr. Hoerricks' unique perspective, as an autistic person, a self-described Gestalt processor, seems key to seeing these connections.
Seeing the whole picture, the patterns that connect seemingly disparate parts.
Exactly. Spotting the underlying logic, the system dynamics that others might just see as isolated incidents or standard procedures.
And maybe the act of just naming that pattern, of making those invisible harms visible, like Dr. Hoerricks does, maybe that itself is a form of resistance.
A crucial first step, yeah. You can't change what you don't see or can't name.
Absolutely. It certainly makes you think, makes you wonder where else this dynamic might be playing out.
Right. Where else in our communities, in our systems, maybe even in our own lives, does this deference to institutional discretion potentially mask real harm? What other patterns are waiting to be recognized?